case briefs, and so much more. LSData's got what you're looking for.
On the heels of a misrepresentation verdict rendered against the company during a merger suit led by the SEC, Parklane Hosiery Co found itself embroiled in another legal scuffle. This time, it was against the displeased shareholders, who looked to employ a legal tool known as offensive non-mutual issue preclusion to avoid the tedium of a second trial, centering on the same issue. The dissolution of the so-called mutuality of parties doctrine, previously a necessity for invoking this notion of collateral estoppel, came in the precedent of Blonder Tongue Laboratories Inc. v. University of Illinois Foundation. This change gave birth to a debate on the potential for exploiting it unfairly against defendants, suggesting that courts should judiciously decide when it's appropriate. With renewed vigor and armed with the previous verdict, the shareholders filed a motion for partial summary judgment against Parklane Hosiery Co. The district court resisted this maneuver in favor of preserving the company's Seventh Amendment right to a jury trial. Ironically, it was Parklane that appealed, arguing that applying offensive collateral estoppel would infringe on its Seventh Amendment rights since the previous SEC trial had been decided by a judge, not a jury. The appellate court thought otherwise and reversed the district court's decision. It upheld that offensive collateral estoppel was permissible. Given that the respondents, the shareholders, weren't in a position to join the earlier SEC Act and the application presented no unfair prejudice against the petitioners, Parklane, this tool was acceptable. Drawing from the groundbreaking Beacon Theater's ruling, which found an equitable determination could possess a collateral estoppel impact on subsequent legal battles, the court stated that the absence or presence of mutuality of parties bore no significance to the Seventh Amendment's interpretation. It also clarified that the law regarding collateral estoppel had evolved since its inception in 1791, and hence is in no way at odds with the aforementioned amendment. Thus, if a party is barred from revisiting factual issues saddled against them from a previous judgment, the Seventh Amendment mandates no different outcome.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.